Hello, I'm Mark Warner, a judge from the 17th Judicial District. We're going to talk about subpoena duces tecums, or subpoenas to produce. Rule 17 of the criminal rules generally governs court orders for production of documents and tangible evidence for the parties. Important issues to keep in mind are: a victim or witness is not a party. Therefore, the court cannot assume a waiver of privilege or privacy based upon that status. The rule requires production of tangible evidence to the court at a trial or hearing. However, the return date may be set prior to the court date to allow adequate time for the parties to inspect and copy the materials prior to the trial or hearing. Court approval is required for the production prior to the trial or hearing. The purpose of the rule is not for discovery of tangible evidence, but rather for the production of such evidence. The disputes that often arise concern issues of privacy or privilege. The disputes may also involve proprietary information. If this is the case, protective orders may be required. The disputes involving a subpoena to produce most often arise in sexual offense sort of cases and when a peace officer is named as a victim. For peace officers, the subpoena will often be for personnel and disciplinary records, and the city attorney will most times object. For sexual offenses or similar cases, the party may seek school records, human services records, and counseling or therapy records. In the foregoing cases, the prosecuting attorney will typically have standing to object to the third-party subpoena. One ground under the rule is that the subpoena is unreasonable or oppressive. Consider whether the materials implicate privilege or privacy concerns. The other considerations are generally set forth in People v. Spikestra, a Colorado Supreme Court case. Number one, a reasonable likelihood the materials exist based upon a specific factual basis. Number two, the materials are evidentiary and relevant. Number three, the materials are not otherwise procurable reasonably in advance of trial by the exercise of due diligence. Number four, the requesting party cannot properly prepare for trial without production and inspection in advance of trial, and failure to inspect will tend to cause an unreasonable delay. Number five, the application is made in good faith and is not intended as a fishing expedition. Special considerations may also apply to special subpoenas, such as for school records. Those are covered under the Family Educational and Privacy Act. A case, People v. Batchoffer, found at 192 Pacific 3rd 454, explains the procedure. If there's no consent from the student or parents, the court must balance the interests. Social services records are covered under the Juvenile Code, and the statutory provisions govern rather than the rules of criminal procedure. That is explained in the case of People v. Jowl at 199 Pacific 3rd 38. Medical and substance abuse records are covered under the General Privilege Statute in 1390-107, also under HIPAA, and substance abuse privacy regulations under CFR Title 42, Part 2 of the Federal Code. Victim compensation records, typically for restitution hearings, are governed by 24-4.1-107.5 of the Colorado Revised Statutes. Victim advocate records are covered under 1390-107 for domestic violence and sexual assault cases. However, that does not include an advocate employed by a law enforcement agency. Post-charge subpoenas from the prosecuting attorney in the context of a criminal prosecution allow the defendant to challenge the demand for production of records on the grounds of lack of probable cause. If determined that the subpoena is appropriately issued, the court may often have to go through the time-consuming process of an in-camera review of the materials and redact some of the information contained in the materials. Care should be taken to ensure that those materials redacted are available for appellate review.